Stabilizing braces. They're popular. Millions of people have them, but soon federal regulations are changing.
To have stabilizing braces attached to their handguns could face federal charges if they don't comply with new regulations.
It's to ATF's rule on firearms with attached stabilizing braces, or what we call the pistol brace rule.
Redefines these stabilizing braces as a short-barreled rifle.
Well, tonight, multiple Arkansas sheriff's offices are pushing back against a new gun policy from the ATF.
Support Senator Kennedy's resolution of disapproval of the ATF's stabilizing brace rule.
You'll be required to register that brace or face serious penalties.
Legal battle over firearms. The case of Watterson v. ATF revolves around a challenge to the ATF's rule regarding arms equipped with stabilizing braces, which subject them to heightened regulation under the National Firearms Act, NFA. District Judge Amos Mazant of the Eastern District of Texas issued the decision in March 2023, departing from previous rulings on similar cases. While other courts invalidated the rule on administrative law grounds, Judge Mazant upheld it in Watterson. Notably, there is no nationwide injunction against the rule, although several courts have found administrative law issues with it. In Watterson, Judge Mazant initially issued a temporary injunction against enforcing the rule, but only until the Fifth Circuit's decision in a related case, Mock v. Garland. Following the Fifth Circuit's decision in Mock, Watterson requested clarification from the court, seeking permanent relief from the ATF's rule. In August, Judge Mazant granted this motion, acknowledging the likelihood of success on the merits under the Administrative Procedure Act.
Stabilizing braces. They're popular. Millions of people have them, but soon federal regulations are changing.
It's to ATF's rule on firearms with attached stabilizing braces, or what we call the pistol brace rule.
Support Senator Kennedy's resolution of disapproval of the ATF's stabilizing brace rule.
Redefines these stabilizing braces as a short-barreled rifle.
However, the court did not explicitly enjoin the ATF from enforcing the rule against Watterson. Watterson then appealed to the Fifth Circuit, arguing that the court's failure to conclusively address the relief requested amounted to a denial of his motion for a preliminary injunction. The Fifth Circuit remanded the case back to Judge Mazant in November, prompting further briefing on the matter. These procedural back and forth underscores the complexity of the legal landscape surrounding the ATF's brace rule. While some courts have halted its enforcement for specific plaintiffs, the rule remains in effect overall, leading to a patchwork of injunctions across different jurisdictions. Watterson's case adds another layer of complexity, as it navigates the intersection of administrative law challenges and Second Amendment considerations. Ultimately, the outcome of Watterson v. ATF could have significant implications for the regulations of arms equipped with stabilizing braces. Depending on the court's final ruling, it may clarify the legal standards governing the ATF's authority to promulgate such rules and the extent to which they implicate individuals' Second Amendment rights. Legal analysis: Watterson v. ATF. The judge's following March 1 judgment took an unexpected turn. It determined that Watterson did not make the identical administrative law allegations that the Fifth Circuit upheld in Mock, and hence was not automatically entitled to relief under that judgment. This was notwithstanding his previous statements in the matter. Watterson did not, according to Judge Mazant, offer a mock-style argument that ATF violated the notice and comment process in promulgating the rule. Rather, he simply expressed substantive concerns to the rule, saying it was outside of ATF's assigned authority to issue. Taking into account the Fifth Circuit's ruling in Mock, Judge Mazant ruled that these challenges were ineffective at the preliminary injunction stage. First, he rejected the plaintiff's claim of unconstitutional agency delegation and separation of powers, stating that the final rule is needful and necessary to carry out the NFA's provisions. and that the ATF holds the delegated authority to administer and enforce the NFA. In the following round, the court evaluated Watterson's APA-based arguments. The complaint alleged that the ATF overstepped its authority by modifying the statute's simple meaning. He went on to suggest that the regulation was problematic because it addressed the major questions doctrine, and that a court should infer that Congress did not give the ATF the authority to determine whether braced pistols were classified short-barreled rifles.
Who have stabilizing braces attached to their handguns could face federal charges if they don't comply with new regulations.
They're a popular item. They sell hundreds a year. And for some guns, they require the braces on their shooting range.
Those who use an attachment called a brace stabilizer will now have to register their weapon with the government.
The ATF's new regulations say these braces convert pistols into short-barreled rifles.
According to the court's ruling, the final rule here does not rewrite the definition of rifle to encompass additional arms not previously understood to fall within the ambit of the Gun Control Act, but rather provides a framework to determine whether a particular arm equipped with a stabilizing brace is designed, made, and intended to be fired from the shoulder. This contrasts with the case challenging the Biden administration's prohibition on ghost arms. The judge denied the plaintiff's major questions doctrine claim, citing an earlier judgment what the ATF retains delegated authority to interpret words of relevant federal arm control statute. Watterson further alleged that the regulation erroneously stated that it would go into effect before the earliest practical date under the Congressional Review Act. The judge denied the claim, stating that the ATF established a 60-day waiting period before it would initiate any enforcement actions pursuant to the final rule, making any technical non-compliance immaterial. Finally, Watterson challenged the pistol brace ban in a substantial way by using the Second Amendment. The ATF responded by saying that, number 1, the Second Amendment does not apply to stabilizing braces as attachments. Number 2, the final rule applies to pistols with such braces because they are essentially short-barreled rifles, an unusual and dangerous arm not protected by the Second Amendment. And number 3, the final rule's registration and taxation requirements are also not protected by the Second Amendment. First, Judge Mazan addressed whether a stabilizing brace is an arm covered by the Second Amendment. After observing that silencers and other arms attachments are not deemed bearable arms, he concluded that stabilizing braces are only covered by the final rule when attached to a rifle.
Well, tonight, multiple Arkansas sheriff's offices are pushing back against a new gun policy from the ATF.
New federal regulations for pistol stabilizing braces were announced just last week.
A pistol stabilizing brace allows users to strap their gun to their forearms or place them on their shoulders for more stability.
ATF is putting out new regulations saying if you add this onto a gun, you're going to have to register it with the government.
This ruling has effectively, and for now at least, killed ATF's pistol brace rule.
This is because registration rule applied to braced pistols rather than the braces themselves. So it appears that Judge Mazan agreed with the premise that a pistol equipped with a stabilizing brace is, as a whole, an arm protected by the Second Amendment. Nonetheless, the judge concluded that braced firearms did not qualify as dangerous and unusual under Heller, hence the amendment did not protect them. The judge, citing Heller and Miller, stated that short-barreled rifles are uncommon and possibly hazardous arms. The judge argued that because a pistol equipped with a stabilizing brace subject to the final rule effectively becomes a short-barreled rifle, it too likely becomes a dangerous and unusual weapon not protected by the Second Amendment. The judge had to reach this conclusion. The braces could not have been in common use for lawful purposes since braced pistols are intrinsically dangerous and unusual, according to binding precedent. Implications. Although the court believed that this was sufficient to answer the Second Amendment challenge, he did briefly address the historical analogy issue. He largely linked it to concealed carry licenses, noting that Bruin backed objective licensing rules. The court decided that the petitioner had failed to demonstrate that the ATF's registration requirements for bracing handguns categorized as short-barreled rifles were akin to the types of two onerous registration restrictions for concealed carry that the Bruin majority had mentioned. The judge would have specifically ruled that the plaintiff cannot show that a $200 tax is so exorbitant that he is effectively denied his Second Amendment right to bear arms, and that the several-month wait for registration approval is not lengthy enough such that plaintiff's Second Amendment right is denied.
This rule is a dangerous attack on every American's Second Amendment rights.
Not one crime that I've ever seen, Mr. Hunt, was a stabilizing brace.
TV11 Sarah Habakowitz explains the debate about what's legal and what might not be legal.
The federal government shall not infringe on the rights of legal gun ownership.
You'll be required to register that brace or face serious penalties.
In reality, that is really tough to argue against. In the Miller case of 1939, the court decided that the shot arm with a barrel less than 18 inches was not protected by the Second Amendment. Heller went on to say that arms not generally possessed by law-abiding citizens for lawful purposes, such as short-barreled shotguns, are not protected by the Second Amendment. However, this is simply another example of how excluding all scientific information from Second Amendment issues does not always guarantee the right to keep and bear guns. This is especially relevant given that pistol braces were originally designed to assist injured veterans fire more accurately, and they may still be effective in that regard. That's all for this video, folks. See you next time.